All right, welcome, Mr. Polderman. If you'd like to put your appearance on record.
Good afternoon, Your Honor. John Polderman on behalf of the successor conservator, Charles Bullock.
Thank you. We're on record today, as you're aware, I'm sure, to review the error in the calculation of credit for time served as it relates to Mr. Dale Warner, since he was given credit for 8 days as a result of we didn't do the calculation in-house. They do it across the street. So when they looked at the file, apparently what happened was they saw that he had done 8 days on contempt and saw contempt again and gave him credit for 8 days on the civil contempt towards the criminal contempt, which was obviously not appropriate. So today's hearing is to review that issue and to hear the attorney's recommendations. I wanted to clarify it for the record as to what happened. And then secondly, to allow the attorneys to be heard on any arguments that you may have as far as what should be done to remedy that at this point. Secondly, Mr. Head has raised the question of the stay, the automatic stay that's directed by the statute when there's an appeal for purposes of 21 days. I also have the motion for reconsideration. He's requested a stay past the 21 days. I had articulated that effectively I was going to make a ruling on the motion for reconsideration as well as the issue that was up for today. There is no automatic hearing on the motion for reconsideration. So I think that catches you up. Mr. Head, would you agree or disagree?
Yes, as long as we are acknowledging the fact that there is a statutory stay. Yes.
Yes, for 21, yes. You cite 600.867. I have read it. Yes.
Just clarification, I think Mr. Head has withdrawn his motion for reconsideration. That's what I heard.
I don't know if you, is that what you want to do?
Unless the court's going to set aside the judgment of contempt.
The motion for, I'm just going to cut, I'm not going to allow you to do that because I've already got an order on it. So I'll issue this today and you'll be able to take that with you. And if the Court of Appeals doesn't like it, I'm sure they'll let me know.
Okay. So if I understand, Your Honor, you want us to still make a record or at least preserve arguments related to this 8-day potential issue. Okay. Well, aside from the stay, there's a doctrine called credit for time erroneously at liberty. And that has been recognized in several states, including the state of Michigan in People versus Lewandowski. That's 237, Mishap 612. It is acknowledged and recognized in the footnote in that case. It's also been recognized by the 1st, 2nd, 3rd, 5th, 6th, 7th, 8th, and 9th and 10th circuits in federal court. The doctrine is essentially coming out of the common law, and it states that a convicted person is entitled to credit against his sentence for time that he was erroneously at liberty, provided there's a showing of simple or mere negligence on behalf of the government, and provided that the day in the execution of the sentence was of no fault of the prisoner. That's what happened here. Essentially, that's what happened in the Lewandowski case, which refers to other cases from other circuits, where a prisoner is erroneously let out of the jail or prison through no fault of his own. In other words, if he didn't escape. That's essentially the government is stopped from playing cat and mouse with him and putting him back in jail. And he receives credit for that time that he's erroneously at liberty, as long as it's through no fault of his own. So under that doctrine, this court, should it be so inclined, and I know Your Honor has not set forth what your opinion is or what your intentions are, but if this court was inclined to make the attempt to reincarcerate him for that reason, this court cannot do so under that doctrine. Aside from that doctrine, there's waiver and estoppel. There's several courts have held that, again, when a government is stopped from playing cat and mouse, this is a direct quote, the government is not permitted to play cat and mouse with a prisoner, delaying indefinitely expiration of his debt to society and his reintegration into the free community. And again, that's from People versus Lewandowski, which I already cited on the record. It also was citing Dunn versus Keohane, which is 14 F3D 335 out of the 7th Circuit Court of Appeals. The decision to release Dale here was not this court's, it was the jail's. Whether that was erroneous is immaterial. for the purposes of our discussion here today. In addition to the waiver and estoppel theory and the time for erroneous ad liberty theory, it's also a violation of Mr. Warner's constitutional rights, both under the United States Constitution and the Michigan Constitution, to reincarcerate him at this point that he's been let free after serving a portion of his sentence after the court found that he was in contempt of court. More specifically, it would be a violation of Michigan Constitution, Article 1, Section 16, and the 8th Amendment of the United States Constitution, which both of which prohibit cruel and unusual punishments. And under the Michigan Constitution, it's cruel or unusual punishments. The federal Constitution is and. The idea of reincarcerating Dale is abhorrent, quite frankly. And if not shocking to the conscience, I don't know what is. There's nothing more cruel or unusual than releasing an inmate, then waiting 2 weeks after he reintegrates with his minor child, and then saying he's got to go back because somebody at the jail messed up. So that would certainly be unusual. I'm sure nobody in this room's heard of that. And my 15 years of practice, I've never seen or heard of anything like that. So because of the fact that it's unusual, it's unconstitutional under the Michigan Constitution. And it's also cruel and unusual under the federal Constitution. There have been some courts that have opined on that issue. For example, O'Brien versus Saginaw County, 437 FSUP 582 out of the Eastern District of Michigan from 1977. The court said in determining whether the conditions of confinement of convicted persons constitute cruel and unusual punishment, the courts have increasingly viewed the effect of the incarceration on the individual. So the prison conditions should not threaten a person's sanity, physical or mental health. And certainly releasing somebody from jail and then requiring them to go back after a period of time would certainly affect their sanity. So for all of those reasons, in addition, Your Honor, once there's been a valid sentence, the court cannot amend a valid sentence once it has started to be served. The court simply just doesn't have that ability. And that is under a court rule. And that is, I believe, that is MCR 6.429. The court may not modify a valid sentence after it has been imposed, except as provided by law. And again, there's no law that permits the court to amend its sentence or to reincarcerate Mr. Warner after he's been released from jail. Additionally, the credit for time served is determined by the jail. I'm not sure of a specific statute or court rule that has a uniform rule. I know that different jails have different credits that are applied for good time, and that's an issue that was that's in play here. And finally, MCR 7.208 provides that once a claim of appeal has been filed, the trial court may not amend or set aside the judgment or order appealed from. So there cannot be any amendment to the sentence at this juncture. So aside from the fact that these proceedings are stayed, the court does not have the ability to reincarcerate Mr. Warner at this juncture. And we would ask for a ruling on our motion for a stay pending the outcome of the claim of appeal that we filed, so that we can get that ruling and we can present it, and if it's denied, we can move the Court of Appeals for a stay pending appeal. Thank you.
Thank you. Mr. Polderman, would you like to be heard on this issue?
Yes, Your Honor. A number of things. One is the Court of Appeals has jurisdiction upon.
And Mr. Polderman, it's very difficult to understand you. You're breaking up a little bit. So I don't know if you could, hopefully you're safely pulled over and not actually moving at this moment. I think we'll have to ask you to, it's muffled. we'll come back to you in a few minutes then, once you've been able to find a safe place that you could maybe stop for a few minutes. Mr. McFarland?
I'll be at the courthouse in 5.
Your Honor, this is not an amendment of a sentence. This is actually carrying out a sentence that was given by this court. These sites that I've heard, I haven't heard any site that's a Michigan site. I could be wrong, but these seem to be federal sites, federal court. They could be used for persuasion, but we're not mandated to follow those. So by this reasoning, if you have somebody, I'm not saying this is this case, but if you have somebody convicted of murder and they are released, I find it hard to believe that Court of Appeals or Michigan Supreme Court is going to say this person is out free, that their time has been served. It's cruel and unusual punishment. When given a life sentence, they don't expect anything. They should expect to be released sooner. Dale Warner likewise was given some certain sentence, Your Honor. There was a certain amount, there was a certain time. He had counsel. It was quite clear. We don't have any transcripts to indicate to the contrary that the court was ambiguous. Matter of fact, it was very clear. Does Mr. Warner have a responsibility, or at least an ability to say, I understand I was in court, I shouldn't be released as early? That's a question. None of these cases that were cited, although I don't have copies, they haven't been right with me, but I don't believe that any of these cases deal with the jail's policy on releasing early or not. I think it was just a miscalculation. This is not a new or an amendment. This is an existing order. I think the court had the ability to issue a bench warrant as soon as it discovered that. So this is not something new. We're not halting something. There's already an order. He spends the time in jail. Probably could be clarified by a bench warrant, but the court is allowing counsel to order. I do not believe it's stayed by the appellate process, Your Honor. And that's my position.
Ms. Berger?
Yes, thank you, Your Honor. I am in agreement with Mr. McFarland on this point. I also do not believe that these proceedings are particularly stayed. I've reviewed the court rules and I can't find anything that exactly pinpoints to this type of ruling that's been made in the past in a probate proceeding. And in that regard, I defer to the court. In relation to the issue of the 8 days that were not served by Mr. Warner, I think that it's very relevant and very pertinent to know that, by my opinion, which will be evidenced by pleadings that will be filed in this court very soon, that Mr. Warner has continually been in violation of this court's order while he was erroneously released. I do not have those ready to be filed today. Otherwise, they would have been presented to you before today. However, there are several incidences where he is attempting to operate business through the farm, where he is directing others to violate the court orders through himself and at his direction. And I believe that, in addition, I believe that his absence from this court today is further evidence of, I suppose, his inability to follow the court's order. If Mr. Warner would have been released and we wouldn't have any of these issues, if literally new information about other vehicles that are owned by the estate or in part by the estate wasn't servicing within the last week, I would probably have a different position. Is it unfortunate for Mr. Warner that he may have to go back and serve those 8 days? Sure, it might be, but it's also unfortunate that he literally cannot help himself from violating these court's orders over and over again. So I'm asking that he be remitted back to jail, that he be ordered to serve those other 8 days. That I would ask that there's a finding that this is not an amendment of a sentence, that it's just carrying out of a valid sentence. And maybe by not ordering him back, that would be an amendment of your sentence. And because there is an appeal filed, we can't do that. So I think your only option, Judge, is to remand him back to the jail. Thank you.
Yes, Your Honor. I also agree with Mr. McFarland. I agree with Ms. Berger as well. I also looked and tried to find case law and other law that would be on point here as far as the stay, given the fact that the motion for reconsideration was filed, gives the court an opportunity to correct or change or do anything that it wants to do, and then an appeal gets filed later. So I was thinking that no, would not be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your Honor's judgment, and you'll know what to do on whether or not Mr. Warner should go back for 8 days. On behalf of Angelina Warner, I have to say that no, he should not go back. She was delighted to have him home. She was surprised, as we all are, because she wasn't expecting him for another 8 days. But she just really, it'd be very hard on her, devastating, judging by her reaction to seeing him when she came home that day. It would just be extremely upsetting for her, for him to go back for 8 days. That said, I leave it to the court's discretion, for the court's judgment. Thank you.
I think Mr. Holderman, did you want to?
Yes, Your Honor. I'm actually in the courthouse parking lot. I was able to make it here, but I would agree with what Mr. McFarland has said as far as this not being an amendment of the court's order. It would be actually just carrying out what the court had already ordered. And on this issue with the Court of Appeals having jurisdiction, MCL 600.308 provides that the Court of Appeals has jurisdiction of all final orders. The fact that the motion for reconsideration is still pending means that there is not a final order of the court at this time. So I would submit to the court that there's actually not a stay on this proceeding today, and the court should enforce its order. The fact that someone was released early does not negate a valid order of the court. And I guess if the court is still concerned about that issue, I think we should have a chance to respond in writing to these cases that Mr. Head has cited. I don't know that any of them are directly on point or speak to criminal contempt, which is a violation of the court's order and affront to the dignity of the court. And the court has the ability to ensure that its orders are enforced and carried out. So in short, there is no stay. This court has the jurisdiction and authority to enforce its orders. There's nothing cruel and unusual about the Lenawee County Jail. That's not what's before the court today. And it's certainly not an amendment of this court's order. As Ms. Berger said, if in fact the time were shortened, that would be an amendment rather than enforcing it as written.
Thank you. Go ahead.
Thank you, Your Honor. With all due respect to Mr. Polderman, there is actually a court rule directly on point. That's MCR 7.208. That's the authority of court or tribunal appealed from. And that says limitations, subsection A. After a claim of appeal is filed or leave to appeal is granted, the trial court or tribunal may not set aside or amend the judgment or order appealed from, except by order of the Court of Appeals or by stipulation of the parties. So there's also criminal contempt is a crime, and therefore an order finding a party in criminal contempt of court and sanctioning the party is a final order from which a contender may appeal as of right. And that's in Ray Maroon, 295 Mishap 312 from 2012. So this, but because there's been a claim of appeal filed from a final order, it's very clear that a judgment of contempt is a final order. And because we have moved to withdraw the motion for reconsideration, even if the motion for reconsideration were to somehow render a final order not a final order, which is not the case, but even if it did, we've moved the court to withdraw. But that's not what the court is going to do. I understand the court's going to issue a ruling anyhow denying it. Regardless, that order is going to be entered one way or another. And the claim of appeal has been filed, and therefore this court no longer has jurisdiction to do anything with respect to that order, especially when that statutory is in place. The issue that this court may have with respect to Mr. Warner not serving what this court believes was his full sentence is between this court and the jail. It is not between this court and Mr. Warner at this juncture. He was out for not a full 9 days prior to the claim of appeal being filed. And after that, now he's been out for a full 15 days. So he should receive the credit for that he deserves under the doctrine of erroneous time and liberty, which is recognized by the state of Michigan and People v. Lewandowski, as I cited. And for all the reasons I've otherwise said. The other issue is with respect to what Ms. Wilhelm indicated. It would be detrimental, it would have collateral effects to the Warner family, especially young Angelina. And it's certainly not fair to her that the jail decided to, in this court's view, release Mr. Warner early. This court knows from collateral proceedings, from other proceedings, the detrimental impact that Mr. Warner's incarceration had on Angelina, as was previously expressed in the minor guardianship case from her counselors, from the guardian ad litem, from the Department of Health and Human Services. So if this court were so inclined to believe that it does have the authority to reincarcerate Mr. Warner, I hope that this court would take that into account and consider the overwhelming and overriding collateral consequences of such a ruling. But again, for all the reasons I've stated, I don't believe, with all due respect, that this court has that authority at this juncture. I would be remiss not to mention, while I was not here for the prior proceedings, Mr. Warner was jailed for violating a civil court order. He was not jailed for a violent offense. He was not jailed for assault or a domestic assault or a battery or some type of a violent crime, some type of a drug crime, some type of a crime with a victim. There was not that type of an issue here. And while I was not present for those prior proceedings, and forgive me, I know that I don't know the entire history, it's surprising to me, because I do practice in criminal defense, that Mr. Warner was jailed for such a length of time when I have seen, even just today, numerous dozens of criminal defendants that are charged with violent crimes that are sentenced to less. Just the court using its equitable powers, I would hope, would factor that in if the court does believe that it does have the authority to reincarcerate Mr. Warner at this juncture as well. Thank you.
All right, as it relates to the request to stay, I appreciate you bringing to the attention of the court MCR 7.208 because it does clarify, I think, in part, some of the decisions that are being submitted to the court today. For example, subsection D indicating probate actions that the probate court retains continuing jurisdiction to decide other matters pertaining to the proceeding from which an appeal was filed. There is no amendment to the opinion that the court previously ordered. This is properly considered certainly something that pertains to the proceedings from which the appeal was filed, but is not addressed in any way, shape, or form by the record. The court is also allowed to look at defects in the record under subsection C. There's also the fact that this motion for reconsideration really concerns the appeal. It has not been addressed, which would mean that we do have effectively an incomplete record for the Court of Appeals to review. And it does raise issues that will be addressed by the court in part, and those will be obviously very important for the Court of Appeals to consider. So for all those reasons, the court does have the authority to rule on the issues that have arisen today, including, of course, on the request for stay, which is denied. I do not think in this particular action, especially where we have the litany of examples of disregard for the court's authority by Mr. Warner up to this point, and apparently potentially continuing, that it's appropriate to allow the proceedings to stay. That creates an unreasonable barrier for those that have been appointed as conservator and attorneys to be able to properly adhere to their fiduciary and legal obligations to the estate and those that they represent. Further find that the ruling on the motion for reconsideration is appropriate to complete the record and to make a decision on the error that was made in calculation of the credit that was given to Mr. Warner. I'm not going to reincarcerate Mr. Warner. Part of the beauty, I believe, in living in the United States of America is that we do have the opportunity to look at issues of liberty, and when in doubt, we should look at them in the most civilized way as possible. In this particular situation, he certainly should have had that additional 8 days. He may, in fact, be subject to the court's proceedings again in the future, according to what I'm hearing today. So on one hand, I think it's appropriate to close the door on that issue to honor the liberties that we all adhere to and uphold in our country, frankly. That was cited in many jurisdictions on the federal circuit. And so I think there's plenty of authority there. And I also don't believe that it serves the interests of Angelina Warner. And I also don't believe that it was part of the intention of the court to put Mr. Warner through another arrest booking process that was not contemplated by the original order. So we will allow him to remain outside the confines of the Illinois County Jail until and unless there are issues that arise in the future. We'll close the door on that particular chapter. And finally, the court's order after the motion for reconsideration will also be issued today. And there will be an evidentiary hearing set on effectively what is the request for a Ginter hearing. So if I could ask you all to look at your schedules, I'd like to look at some dates and times for that.
Your Honor, I would ask for a finding of fault be placed on the jail. Specifically in your order, I'd like to preserve that for the record. I would also like to get that order in writing. I don't have a client. I've said that 100 times, she's not here. But I do know that if she were here, she would want the people responsible for letting Mr. Warner out of jail erroneously held accountable. And I don't know what will follow, but I'm asking for that written order today. Thank you.
Frankly, I don't want to say that it's simply the jail. All of us sitting here today in this room had the ability to calculate that appropriate release date and to make sure that that was communicated effectively to the jail. Asking our jail personnel to differentiate between civil contempt and criminal contempt under the same case file number was understandably out of the ordinary for them, frankly. So I think that as much as I would love to say that it is simply their fault, I think that we all sit responsible in some part for the miscalculation. And I just want to say that frankly, I'm glad to see that the error is made on the side of liberty rather than on the side of incarceration. That's part of, again, the reason why we have the benefits of living in this country. So I appreciate your frustration and your request, Ms. Berger, but I'm going to deny it for those reasons.
Thank you, Judge.
Anything else?
That's fair.
Okay, all right. So on the effectively what we're referring to as the Ginther hearing that was raised in the motion for reconsideration. I have Friday, December 22nd, or then I have to go into January. Any preferences?
I have court closed on December 22nd, Your Honor.
Great. Then I can clear that whole day. January it is. I can give you a. Let's see. Well, let me ask you this. How much time do you think you're going to need, Mr. Head? How many witnesses do you anticipate?
I can think of at least 6, so we're probably gonna have, it's probably gonna be a lengthy hearing. If our motion for stay pending appeal isn't granted by the Court of Appeals by that time, I think the court should at least allow the Court of Appeals that time to rule. So I think January would be more appropriate.
I would not, and that this is probably going to appear presumptuous, so I apologize to our Court of Appeals in advance. However, I have seen in other cases that for purposes of the Ginther hearing in particular, even if they granted your motion, they would be asking me to have that hearing anyway. So I would prefer to simply schedule it and get it done, rather than awaiting their directive on that point.
Understood, Your Honor.
So how about Friday, January 19th for starters?
Judge, I'm sorry, I'm out of the country.
All right, when are you back?
I'm back on that Sunday. I'm out the 18th and 19th.
I can give you a backup date on the 22nd, 23rd. And give you those 2 days as a backup to a bench trial. Is everyone clear on those 2 days?
I am.
That works for me, Your Honor.
All right, so.
I am, Your Honor, I do have a pretrial, but it is at 8 o'clock in the morning on the 23rd. That should be over now.
So if we start at 9, would that
That
accommodate
would
that?
be fine. I'm sure I'll be finished by then.
All right, very good. So we'll start at 9 a.m. each day, January 22nd and 23rd. I would ask that, your witness and exhibit list be filed by the end of the year. Should be easy to remember so that we can have a look at that and determine whether or not that's going to be enough time. Previous to that, are you available for a pretrial conference on that on Friday, January 12th at 9?
Yes, Your Honor.
Can I ask the
Yes,
time
sir.
on the 22nd, Your Honor?
9 a.m. each day.
Thank you.
9, 9, and 9. The 12th, 22nd, and 23rd is what I'm suggesting.
Yes, the 12th, January 12th does work for me too, Your Honor.
At what time are you considering on the 12th, Your Honor?
9 a.m.
I'm available.
Any other questions? All right. Thank you all for your time and your hard work on this case.